The 26th Amendment attacks independence of the judiciary, and to that extent, the 26th Amendment of the Constitution is liable to be struck down on the basis that it violates a salient feature of the Constitution. The petitions regarding the 26th Amendment and challenging the validity of the 26th Amendment are pending before the Supreme Court. It remains to be seen whether the Supreme Court is of the view that the 26th Amendment satisfies the procedural and substantive threshold for striking down a constitutional amendment. In today's case in point, we'll talk about whether the court and whether the Supreme Court has the authority to strike down a constitutional amendment. The 26th Amendment to the Constitution has been passed by the National Assembly, it's been passed by the Senate, and it has also received the President's assent. And now several petitions have been filed in the Supreme Court challenging the validity of the 26th Amendment. The Supreme Court has also been asked to strike down the 26th Amendment. In 2015, in the District Bar Association case, a majority of the Supreme Court held that the court has the authority to strike down a constitutional amendment on both procedural grounds as well as on certain substantive grounds. Even though Article 239, subsection 5, bars the courts from calling into question any constitutional amendment, the Supreme Court interpreted this article and held that it does not apply to the Supreme Court, and the ouster does not engage for the Supreme Court, and therefore the Supreme Court retains the authority to judicially review a constitutional amendment and to strike it down. Firstly, let's talk about the procedural grounds on which a constitutional amendment can be struck down. Article 239 of the Constitution commands that a constitutional amendment must be passed by 2/3 majority of both houses. Now, as far as the Senate is concerned, the votes required for a 2/3 majority are 64 votes. The 26th Amendment was passed by 65 votes. As far as the National Assembly is concerned, the 2/3 majority required is 224 votes, and the 26th Amendment was passed by 225 votes. In both houses of Parliament, the 26th Amendment has been passed by just 2 votes more than is required for a 2/3 majority, and this is a razor slim majority in both houses of Parliament. So if the Supreme Court reaches the conclusion that 2 votes in the Senate or 2 votes in the National Assembly were improperly procured, they were a result of coercion, of duress, of unlawful inducement, then the entire constitutional amendment is liable to be struck down on procedural grounds. This is not a controversial position, and if votes have not been voluntarily cast, if people have been forced to vote, and if they have not voluntarily cast their vote, then the entire constitutional amendment is liable to be struck on this ground alone. However, if the Supreme Court reaches the conclusion that the procedure was valid, then the constitutional amendment can also be struck down on substantive grounds. Again, in the District Bar Association case, a majority of the Supreme Court held that if a constitutional amendment violates a salient feature of the Constitution, it is liable to be struck down. The salient features of the Constitution include a parliamentary democracy, an independent judiciary, fundamental rights. To the extent that any constitutional amendment violates these salient features, it can be struck down. And essentially, the court held that if democracy is replaced by dictatorship, if fundamental rights are suspended or suppressed, and if the independence of the judiciary is compromised, the courts retain the authority to intervene even if the change is brought by way of a constitutional amendment. Now, does the 26th Amendment to the Constitution violate a salient feature of the Constitution? In my view, the 26th Amendment is inconsistent with judicial independence and violates the independence of the judiciary, which is a salient feature of the Constitution. Under the 26th Amendment, the judiciary is not independent. The government and the executive have been given significant control over the judiciary and the internal functioning of the judiciary. The process of appointment of the Chief Justice has changed. The Chief Justice is now to be appointed by a parliamentary committee in which the government commands the majority, and the Chief Justice is to be appointed from a panel of the 3 most senior judges. Effectively, the government has been given a majority say in handpicking the Chief Justice. The government is a party to cases in the Supreme Court, and the government cannot be given a majority say in selecting the head of the institution. and the parliamentary committee is not required to give reasons for their decision, and the proceedings are in camera, the proceedings are secret, and they are not transparent. We saw that the parliamentary committee nominated Justice Yahya Afridi as Chief Justice, and nobody knows the reasons why Justice Syed Mansoor Ali Shah, the senior most judge, was bypassed. The parliamentary committee could be acting entirely for political reasons. The parliamentary committee could be acting entirely for partisan reasons, and nobody will know the reasons for their decision. Constitutional benches have been created at the High Court and the Supreme Court. A commission will decide which judges will sit on these constitutional benches, and the commission has majority non-judicial members. And 5 members are associated with the government, and they include the Law Minister, the Attorney General, a National Assembly member from the Treasury benches, a Senate member from the Treasury benches, and a 5th member to be nominated by the Speaker. This is effectively giving the government a say in selecting which judges will sit on the constitutional benches. Again, the government is a party in constitutional matters, and litigants do not have the right to choose their judges, and litigants cannot decide the judges before which they want to present their case, and this would also impact the independent functioning of the judiciary. The Attorney General is also a member of the commission which selects which judges will sit on the constitutional benches. The Attorney General represents the Federation before the Supreme Court. The Attorney General appears before the Supreme Court, and this would give the government an unfair advantage if the Attorney General is given a vote in deciding which judges will sit on these constitutional benches. By way of example, one of the cases which is pending in the Supreme Court is the appeal regarding the trial of civilians in military courts. Under the current constitutional amendment, this case may be transferred to the constitutional bench, and the government would be given a say in deciding which judges will hear the appeal. The Attorney General defended the trial of civilians by military courts. The government also supported the trial of civilians by military courts, and it would be completely inconsistent with judicial independence for the government to now have a say in which judges will hear the appeal regarding the trial of civilians by military courts, and the same principles would apply in other constitutional cases where the government is a party. An annual evaluation of High Court judges has also been included. The commission that evaluates the performance of High Court judges also includes government members. And if the judges know that they will be subject to an annual evaluation by the government and by government members, this will discourage independent decision making, and the government may misuse this power by rendering a negative evaluation if a judge gives a decision against them. So the 26th Amendment does increase the role of the government in the judiciary quite significantly. And the preamble of the Constitution also states that the independence of the judiciary shall be fully secured. And under the 26th Amendment, the independence of the judiciary is not fully secure, and the 26th Amendment attacks independence of the judiciary. And to that extent, the 26th Amendment of the Constitution is liable to be struck down on the basis that it violates a salient feature of the Constitution. Now, government members are also giving examples of judicial activism in the past and how this is a justification for the 26th Amendment. The fact that the judiciary made mistakes in the past is not a justification to now capture an independent judiciary, and the 26th Amendment will serve only to further politicize the judiciary. And now that the petitions regarding the 26th Amendment and challenging the validity of the 26th Amendment are pending before the Supreme Court, it remains to be seen whether the Supreme Court is of the view that the 26th Amendment satisfies the procedural and substantive threshold for striking down a constitutional amendment.